Hi, welcome to our channel of IGNOU Audiobooks, Indira Gandhi National Open University, School of Law, SOL, Diploma in Paralegal Practice, DIPP, BLE 004 Rural Local Self-Governance, Block-1 Constitutional Framework, Unit 2 Gram Sabha, 2.1 Introduction. Democracy is epitomized by the phrase government for the people, by the people, and of the people. In a country like India with its huge population, the most significant act of assertion of our democratic right comes once in 5 years, when we vote for the formation of the government at the state or the center. Direct democracy, wherein everyone can participate in the decision-making process, cannot be a reality unless we have a system through which people could be closely associated in the decision-making process at the grassroots. Democratic decentralization through the introduction of Panchayati Raj institutions is a step in this direction. Under the Indian Constitution, the village, Gram, has been conceptualized as a self-sufficient entity of rural life and the Panchayat as an elected, democratic entity. The Gram Sabha comprises of all adult citizens residing in a village. It is the cornerstone of the entire scheme of democratic decentralization in India, and the Constitution gives specific importance to this institution. As the basic unit of direct democracy, a Gram Sabha not only elects the Gram Panchayat but also monitors its actions. The success or failure of the Panchayati Raj system largely depends on how powerful and effective the Gram Sabha is to fulfill the desires and aspirations of the people. Various states through their own laws and policies have further empowered Gram Sabhas to take on some administrative functions as well. Further, the Panchayat's extension to Scheduled Areas Act (PSA) confers significantly greater powers on Gram Sabhas in scheduled areas to take on responsibilities and actively participate in governance, rather than just monitor the Panchayat. In this unit, we will discuss the constitutional status of the Gram Sabha and its functions. We will also analyze the functioning of Gram Sabhas and issues that need to be addressed to make them more effective. We will discuss the powers and functions of a Gram Sabha under PSA. 2.2 Objectives. After studying this unit, you should be able to 9. Explain and understand the constitutional significance of the role played by the Gram Sabha. 9. Analyze the functioning of Gram Sabhas. And 9. Explain the powers and functions of a Gram Sabha under PSA. 2.3 Definition of Gram Sabha. The Gram Sabha is the basic unit of direct democracy. In the 73rd Constitutional Amendment, it was conceived as the basic forum for deliberative democracy, where people would participate simply by dint of being citizens of India. This institution is very important as it gives an opportunity to each and every voter of the Gram Panchayat to take part in decision-making, planning and development. Article 243(b) defines Gram Sabha to mean a body consisting of persons registered in the electoral rolls relating to a village comprised within the area of Panchayat at the village level. Article 243(a) states that a Gram Sabha may exercise such powers and perform such functions at the village level as the legislature of the state may by law provide. Article 243(9) defines village to mean a village specified by the governor by public notification to be a village for the purposes of Part 9 and includes a group of villages so specified. This definition permits the governor to declare any populated rural area as a village. The demarcation of a village for the purposes of giving effect to Part 9 of the Constitution may come in conflict with the sociological anthropological notions of village that prevail among the people of an area. The effective constitution of AGS will mainly depend on the definition of a village adopted in various state legislations. While in certain legislations, the definition of a village is coterminous with that of a revenue village. In others, it is based on habitations or groups of villages, laying to rest the various speculations on the possible interpretations and the extent of a state's powers to identify an entity as a village. The Supreme Court, in State of U.P. v. Pradhan Kshetra Samiti, 1 held that, among other things, the process of defining a village must comply with the following conditions. I. The village has to be a habitat according to the anthropological concept. 2. The village for the purposes of the panchayat can be specified only in accordance with the aspirations and wishes of the inhabitants of the village, as conveyed to the governor, who is obliged to notify it without involvement of the state government. And 3. The governor has to act independently of the state government in the matter of specification of a village. As regards the Gram Sabha, the court held that although the definition of Gram Sabha refers to a body of persons registered in the electoral rolls, and the state government has no power to establish or notify a Gram Sabha. The court reasserted the view of the 73rd Amendment that the Gram Sabha is a constitutional entity based on the geographical and sociological entity of a village, and it is not within the powers of the state government to identify or notify a village. For administrative purposes, delimitation of panchayats ought to be attempted on this criterion set out by the Supreme Court. 2.4 Powers of Gram Sabha. There is a great deal of diversity in the provisions of state acts with regard to the functions of the Gram Sabha. However, there are some common features and a synthesis of various powers and functions assigned in different states too. The Gram Sabha reveals the following broad functions. 1. Examine annual statement of accounts and audit report. 2. Discuss report on the administration of the preceding year. 3. Review program of work for the year or any new program. 4. Consider proposals for fresh taxation or for enhancement of existing taxes. 5. Select schemes, beneficiaries and locations. 6. Mobilize voluntary labor and contributions in kind and cash for community welfare programs. 7. Render assistance in the implementation of development schemes. 8. Promote unity and harmony among all sections of society. 9. Seek clarifications from the Mukhya and other members of the Gram Panchayat about any particular activity, scheme, income and expenditure. 10. Consider the budget prepared by the Gram Panchayat and future development programs and plans for the Gram Sabha area. 11. Consider and scrutinize existing schemes and the activities of the Panchayat. 12. Maintain a complete register of all development works undertaken by the Gram Panchayat or by any other government department. 13. Scrutinize the completed works of the Gram Panchayat. 14. Prepare plans for local development including minimum needs, welfare and production-oriented programs. 15. Prepare lists of all able-bodied persons to whom employment is to be provided under local wage employment schemes. We have seen above the broad powers available to the Gram Sabha. However, certain states have vested the Gram Sabha with certain unique powers, thereby giving them additional authority and control over the Panchayat. Moreover, since Gram Panchayats may consist of one or more habitations or villages, some states have provided for creation of smaller entities for each constituency in a Panchayat. For example, Karnataka has created ward sabhas for every ward of an elected member of a Gram Panchayat. The state has conferred several powers to ward and Gram Sabhas, including mandatory identification and prioritization of beneficiaries for all government programs, mandatory approval of developmental plans and proposals, and determining priority of schemes. The list of beneficiaries so decided by the Gram Sabha cannot be changed at any level of the government. Similarly, in West Bengal, a Gram Sansad for each constituency in the Gram Panchayat was established in 1992 and Gram Sabha at the level of Gram Panchayat was introduced in 1994. The Gram Sansad has been given several powers, including identification of schemes that are required to be taken up on priority basis for economic development of the village. Gram Panchayat cannot omit or refuse to act upon any recommendation of a Gram Sansad relating to prioritization of any list of beneficiaries or schemes or programs so far as it relates to the area of the Gram Sansad. The Gram Sansad can also record its objection to any action of the Pradhan or any other member of the Gram Panchayat for failure to implement any development scheme properly or without active participation of the people. The Gram Unnayan Samiti, constituted in a Gram Sansad, has been introduced in the State Act by the West Bengal Panchayat Amendment Act 2003. A Gram Sansad will constitute an executive committee named Gram Unnayan Samiti, having jurisdiction over its area. This Samiti is responsible for ensuring active participation of people in the implementation of rural development programs within its jurisdiction and the equitable distribution of benefits. It is accountable for its functions and decisions to the Gram Sansad. Gram Unnayan Samiti may also constitute such number of functional committees as may be required. Various central legislations have seen the Gram Sabha as a body capable of carrying forward the constitutional and policy goals of recognizing and implementing rights of people and bringing about rural development. These legislations and policies have vested powers and responsibilities in the Gram Sabha that will facilitate community participation in decision-making and make it more effective in monitoring the activities of the Panchayat. For example, under the National Rural Employment Guarantee Act, NREGA, the Gram Sabha is mandated to monitor execution of schemes undertaken in their area and conduct social audits on the progress of these projects. The Panchayat Extension to Scheduled Areas Act 1996 PSA confers power and responsibility over natural resources to Gram Sabhas in scheduled areas and is applicable to 9 states which have tribal areas within their territory that are protected under the 5th schedule to the Constitution. The Gram Sabha in these areas will be competent to safeguard and preserve the traditions and customs of the tribal people, their cultural identity, community resources and customary mode of conflict resolution. We will discuss the PSA in detail later in this unit. Thus, various states have seen fit to vest the Gram Sabha with differing degrees of powers. While the Constitution provides the bare minimum, states which are committed to the idea of decentralization have been constitutionally granted the freedom to empower the institution with as much authority and responsibility as they deem fit. It is, however, a sad reality that not many states have actually taken this opportunity to empower people to effectively participate in the democratic process at the grassroots level. Let us in the next section look at some of the problems that people face in the process of making the idea of direct democracy work at the ground level. 2.5 Analysis of the functioning of Gram Sabhas. As we have seen above, though all state governments have provided for the establishment of the institution of Gram Sabha in conformity with the provisions of the Constitution, their framework in terms of concept, powers and functions vary. Further, the response to the institution from the people and other village-based organizations has also been different. While in some places Gram Sabhas have been vibrant and active, in other places they exist without much impact, with no meetings or thinly attended meetings. Common complaints are that attendance at meetings is thin, agendas are not circulated in advance, and several activities like social audit are only carried out nominally. Another common complaint heard is that officials concerned rarely attend Gram Sabhas. Disillusionment with Gram Sabhas tends to snowball, with office bearers of Gram Panchayats also becoming reluctant to convene meetings as they find it inconvenient to face people. Experiences available from different places indicate that strengthening of Gram Sabhas calls for a wholesome approach, whereby these institutions can be strengthened to be able to play a more effective role in activating participatory process at the village level. For this, the following issues require immediate attention: size and area of Gram Sabha. The membership of a Gram Sabha varies from state to state, ranging from 250 to 5,000. Gram Sabhas may represent only a part of the concerned villages, or they may represent more than one village. This results very often in practical difficulties like managing the numbers or absence of a common venue for holding meetings. In tribal areas or other areas such as desert areas or heavily forested areas where density of population is very thin, organization of Gram Sabha meetings is likely to have its own problems because of the vastness of the panchayat area. The size of a Gram Sabha plays an important role in its overall functioning because of locational problems and its composition. In order to deepen the opportunity for more participation, states could consider establishing ward sabhas at the level of each ward. Gram Sabha meetings. Comprehensive dissimilarities exist in the provisions regarding the number of meetings to be organized every year. Denial of due importance to Gram Sabhas has become a common practice. Meetings of a Gram Sabha are necessary to review and control the panchayat's activities, yet it is the panchayat that has to convene these meetings. Naturally, panchayats are reluctant to convene Gram Sabha meetings and subject themselves to popular review. Provisions are not adequate enough to accord the necessary status to a Gram Sabha which can be effective in making the panchayat accountable. A 1997 study conducted by Sabhagi Shikshan Kandra, Lucknow, covering 15 Gram Sabhas concluded that only 1/3 of them had actually conducted the required number of meetings. Though publicity about the date and time of a Gram Sabha meeting is given through the locally available media, adequate notice is not given. Even when Gram Sabha meetings are well organized, participation of all those present in the meetings cannot be ensured for a number of reasons, chief among them being non-awareness of statutes and regulations pertaining to PRIs. The problem of exclusion based on class, caste and gender is also a weakness in the present functioning. For instance, in Himachal Pradesh, 1 person per family is counted for quorum, rendering the participation of women in not so relevant. The frequency of meetings is an index to the success of a Gram Sabha. And state governments can help by providing incentives to panchayats which organize relatively larger number of Gram Sabha meetings. For example, the government of Odisha has a scheme for giving rewards to outstanding panchayats in each district, and the organization of Gram Sabha meetings is one of the criteria for assessment. Some states have mandated that Gram Sabha meetings shall compulsorily be held on fixed days like Independence Day and Republic Day, which can be an impediment as this reduces spontaneity and undermines local initiative. Quorum in meetings. Insisting on the presence of a minimum number of individuals is necessary so that the decisions are not prejudicial to the larger interests of the community. The non-prescription of quorum may enable vested interests to influence the panchayat's policy. Allowing a reconvened Gram Sabha meeting to proceed, even without a quorum if the preceding meeting was postponed due to lack of quorum, goes against the very spirit of democracy. Studies reveal that persons with vested interests, like powerful upper caste men or persons like the village money lender, are some of the most regular participants in Gram Sabha meetings. It may not be difficult for such interests to influence the few who attend the meetings. A larger number of participants will result in a greater possibility of deliberations and discussions, and decisions taken will reflect the general and uninfluenced views of the community. Sometimes, to address the issue of insufficient quorum, a family is treated as one unit and one person from a family is counted for quorum. However, this has an adverse impact on the participation of women in Gram Sabha meetings. People, particularly the poor, do not want to lose their daily wages for the sake of attending the meetings. Meetings at a time of the day when women and the weaker sections are busy at home or in earning their wages render the meetings meaningless. Status of Gram Sabha. Is the Gram Sabha an advisory consultative body, the acceptance of its advice being dependent on the wisdom discretion of the Panchayat? There are visible inconsistencies in the way Gram Sabhas function in different states. The list of functions indicates that a Gram Sabha has the power only to discuss, debate, examine and scrutinize. Its decisions are not binding on the Gram Panchayat. If a Gram Sabha has to be made functional as it ought to be, it must be endowed with the power to implement schemes. For example, PESA has not only extended development, planning and audit functions to the Gram Sabha, but also endowed it with the management and control of natural resources and the adjudication of justice in accordance with traditions and customs. Madhya Pradesh has extended most of the powers conferred on a Gram Sabha under PESA to all the Gram Sabhas in the state. The Standing Committee of the 13th Lok Sabha on Urban and Rural Development 2002 has recommended that decisions of Gram Sabhas, even in the general areas, should be treated as mandatory rather than just as recommendatory. Unless the role of a Gram Sabha is defined in clear terms to remove any ambiguity about its role, the institution will not grow or function as envisioned. Keeping a Gram Sabha merely as an advisory body will weaken it, as decisions taken in meetings of the Gram Sabha will not be binding on panchayats. The shortcomings which have been experienced in the working of Gram Sabhas are due to the fact that adequate powers have not been conferred on them, and the provisions of state acts lack specificity as far as their hold over panchayats is concerned. In order to make the GS a powerful, vibrant and pulsating institution, it is necessary to learn from the decade-long experience and incorporate the changes that will enable the Gram Sabha to become the fulcrum of the entire scheme of democratic decentralization. 2.6 Empowering Gram Sabhas. The following are some of the recommendations of the Standing Committee of the 13th Lok Sabha on Urban and Rural Development 2002 for empowering Gram Sabhas. 2. While recognizing that Gram Sabhas must be empowered to ensure accountability of Gram Panchayats, emphasis was placed on conduct of regular meetings in which open discussions could be held on structured agenda matters. Two aspects to this issue were identified. A. Practical aspects concerned with convening a Gram Sabha so as to ensure that interest is sustained, and B. Legally empowering the Gram Sabha. Gram Sabha meetings, the date, time and location for a Gram Sabha meeting should be convenient for all to participate. There should be enough publicity for Gram Sabha meetings through the local media and local communication methods such as wall posters, handbills, tom-tom, etc. People who attend Gram Sabha meetings should be encouraged to express their opinion freely so that no single group dominates the proceedings. NGOs may be encouraged to promote awareness and people's participation. To sustain interest in Gram Sabha meetings, agendas must be circulated in advance. A meeting of the Gram Sabha can be preceded by meetings of common interest groups, such as self-help groups, etc., full disclosures of budgets and resources available for planning and implementation should be provided, so that Gram Sabha meetings do not become wrangling matches between groups with high expectations and panchayats that do not have the resources to meet them. There must be a specific duty cast upon the chairperson of the Gram Panchayat to convene Gram Sabhas as provided in state legislations without fail, with punitive measures of being disqualified in case of non-compliance. Similarly, relevant officers must be directed to attend Gram Sabha meetings without fail. And stringent measures should be taken in case these are not complied with to ensure more effective social audit. State governments will need to bring out policies and rules for the conduct of social audit to evaluate the work carried out by panchayats. A voluntary council of experts and eminent citizens can be constituted by Gram Sabhas themselves or initially at higher levels to encourage this practice. Community-based organizations to report to Gram Sabhas. The practice of various community-based organizations working at the village level placing their reports before Gram Sabhas must be promoted. This will also greatly aid in their eventual integration into panchayats. These committees include the watershed development committees, village water supply and sanitation committees, village education committees, joint forest management committees, etc. Even NGOs can report to the Gram Sabha about details of their programs. Standardizing Gram Sabha roles in CSS guidelines. All central ministries must include in their CSS guidelines mandatory measures of reporting plans, progress and social audit to Gram Sabhas convened by the panchayat. Care should be taken in these instructions to position Gram Sabhas as institutions for holding panchayats, particularly Gram Panchayats, to account for their performance through approval of plans, selection of beneficiaries and review of progress. Treating the Gram Sabha as an executive body that can be entrusted tasks by higher levels bypassing the panchayat should be avoided. 2.7 Panchayats, extension to the Scheduled Areas Act PSA. The Parliament passed the Panchayats Extension to the Scheduled Areas Act 1996 to extend the provisions of the 73rd Constitutional Amendment to the areas specified in the 5th Schedule of the Constitution. Scheduled Areas. This act is quite significant as it accords statutory status to the Gram Sabhas in the scheduled areas and confers them with wide-ranging powers and authority. This vital aspect was missing from the provisions of the 73rd Constitutional Amendment. PSA has recognized the prevailing traditional practices and customary laws. Besides providing the management and control of all the natural resources, land, water and forest in the hands of the people living in the scheduled areas. 2.7.1 The context. The tribal community comprises of more than 300 communities, small and big, pursuing different forms of livelihood such as hunting, shifting, cultivation and traditional farming. The ideal of self-governance at the micro-level that the country sought to work towards was already an existing reality in the tribal tracts of the country. In fact, it was a functioning system imbued with the real spirit of an egalitarian democratic order. The strongest challenge to the spread of the British rule came as they entered the territories of the tribal people. The tribal people never acknowledged the authority of the British, notwithstanding the records that they had created as per their perceptions in the form of promulgations, regulations, etc. These formalities had no meaning for the tribal people and in any case, as they did not materially interfere with their traditional systems of governance, they were irrelevant. Hence, the British created the system of non-regulation areas or excluded area, or partially regulated areas or partially excluded areas, depending on the local situation and the sensitivity of the people. The degree of exclusion was dependent on the way the local people reacted to the presence of alien elements and their assertion of authority. This device was mainly addressed to the British officials, so that they may not treat these areas and the people living there like other areas and other people. Fifth schedule, post-independence, our constitution to adopted this two-way classification. The excluded areas were mostly termed as the tribal areas for whose administration special provisions were made in a separate schedule, namely, the sixth schedule of the constitution. The other tribal tracts of the country, corresponding broadly to the partially excluded areas, were named the scheduled areas. Special provisions for the administration and control of scheduled areas have been made under a separate schedule. Namely the fifth schedule of the Constitution. The governor, under the fifth schedule, has the most vital, central and unusual role to play. The governor is the sole legislature for the scheduled areas. The governor can make regulations for peace and good government of these areas. The items on which such regulations can be made include transfer of land, allotment of land and money lending. In making any such regulations, the governor can even repeal or amend any act of parliament or of the legislature of the state or any existing law in force in these areas. However, when exercising such power, the governor is required to consult the tribe's advisory council, a body consisting of representatives of the various tribes in the state constituted to function as an advisory body and a direct link between the TR1BLS and the governor. The governor can direct that any state or central law will not apply to the scheduled areas or will apply with such exceptions and modifications as he may deem necessary. The President can give directions to the states as to the drawing up and execution of schemes for the welfare of the scheduled tribes in the state. The governor of each state having scheduled areas therein is required to annually or whenever so required by the President make a report to the President regarding the administration of the scheduled areas in that state so as to enable the President to give necessary directions to the state. The TR1BLS got caught in the whirl of modern development, industrial and mining complexes, big irrigation and hydel projects, tourist resorts and defense establishments. Disorganization, displacement and destitution became the destiny of the TR1BLS. In many tribal areas, therefore discontent could not be contained and confrontation became the order of the day. Open rebellions brought with it ruthless repression, which by no means could meet the situation. Besides open revolt, the rebellion took a new form in the late 80s in some tribal tracts, particularly in Bastar. The people started asserting their right to manage their affairs according to their tradition and customs. It found symbolic expression in the simple slogan Mawa Nate Mawa Raj or Hamare Gaon Mein Hamara Raj, our village, our rule. The provisions of the 73rd Amendment were not extended to the scheduled areas. It was considered necessary to make modifications before extending them to these areas. This was done in 1996 following the recommendation of the Bhuria Committee through the provisions of the Panchayats Extension to the Scheduled Areas Act. The Act envisages the community at the village level in the form of Gram Sabha as the basic building block of the new system. This provision is unique and stands out in contrast to the general scheme of delegation and devolution of powers by the state, including that for panchayats under Articles 40 and 243G, which wield the ultimate authority in all matters concerning a citizen's life. The acceptance of the competence of the community as a whole in the form of a Gram Sabha and not just of a group of elected individuals is an acknowledgement of the fact that self-management is a natural right of the community. The Gram Sabha has to ensure that land is not alienated and wrongfully alienated lands are restored to the real claimants. Even the state cannot acquire land without consulting the Gram Sabha, which virtually means seeking their consent. 2.7.2 Gram Sabha under PESA, definition of a village in scheduled areas shall ordinarily consist of a habitation or a group of habitations or a hamlet or a group of hamlets comprising a community and managing its affairs in accordance with traditions and customs. Constitution of Gram Sabha. A Gram Sabha is to be constituted for each village, consisting of persons whose names are included in the electoral rolls for the panchayats at the village level. The Gram Sabha is recognized as being competent to safeguard and preserve the traditions and customs of the tribal people, their cultural identity, community resources and customary mode of conflict resolution. It is important to note that PESA has recognized the special powers of the traditional village community by vesting all such powers in the Gram Sabha, thus making it a powerful institution having full powers to manage the affairs of the local communities. Constitution of Panchayats. A panchayat is required to be constituted for each village in the scheduled areas in the following manner. A. The reservation of seats at every panchayat should be in proportion to the population of communities in that panchayat for whom the reservation is sought to be given under Part 9 of the Constitution. However, in making such reservations, the reservation provided for scheduled tribes cannot be less than 1/2 of the total number of seats. B. All the seats of chairpersons of panchayats at all levels will be reserved for the scheduled tribes. And C. The state government will nominate persons belonging to such scheduled tribes which have no representation in the panchayats at the intermediate level or district level, but such nomination will not exceed 1/10 of total members to be elected in that panchayat. The Act requires the states to endow panchayats with such powers and authority as may be necessary to enable them to function as institutions of self-governance. It shall contain safeguards to ensure that the panchayat at the higher levels do not encroach on the powers and authority of any panchayat at the lower level or of the Gram Sabha. In the context of powers vested in the Gram Sabha, the Gram Panchayat cannot have powers which have been expressly provided for Gram Sabha. The Gram Panchayat shall be fully answerable to the Gram Sabha, and thus all scope for conflict is sought to be avoided. Powers of Gram Sabha. Powers of a Gram Sabha as specified in the PESA Act 1996 can be divided into the following four categories. 1. Mandatory powers. 2. Powers to be consulted. 3. Recommendatory powers. 4. Power to be devolved by the state government. The details of these powers are: 1. Mandatory powers. The powers assigned to the Gram Sabha in this category are 3 fold. A. Power to approve the plans, programs and projects for social and economic development before they are taken up for implementation by the village panchayat. B. Power to identify beneficiaries of poverty alleviation programs, and C. Power to give certification of utilization of funds by the panchayats for the above programs. These powers make the Gram Sabha a powerful body in the implementation of projects for social and economic development of tribal communities. 2. Powers to be consulted. The Act has assigned consultative power to the Gram Sabha with regard to land acquisition. It provides that before making acquisition of land in the scheduled areas by the authorities concerned for development of projects, or before resettling or rehabilitating persons affected by such projects in scheduled areas, the Gram Sabha or Panchayat at the appropriate levels will be consulted. 3. Recommendatory powers. Prior recommendations of the Gram Sabha or the Panchayats at the appropriate level will be compulsory in the following matters: I. For grant of prospecting license or mining lease for minor minerals in the scheduled areas, and for grant of concession for the exploitation of minor minerals by auctions. 4. Powers to be devolved by the state government. The Act specifies that state governments will endow panchayats in the scheduled areas with such powers and authorities as considered necessary to enable them to function as institutions of self-governance. To ensure this, the Act specifies that a state legislature will ensure that panchayats and gram sabha in scheduled areas are endowed specifically with powers to enforce prohibition on or regulate the sale of intoxicants, have ownership over minor forest produce, prevent alienation of land and take appropriate action to restore any unlawfully alienated land of scheduled tribes, to exercise control over institutions and functionaries in the social sector and plans such as tribal subplans, to manage village markets and exercise control over money lending. The state government shall also entrust to panchayats at the appropriate level powers in relation to planning and management of minor water bodies. 2.7.3 Implementation of PESA. An analysis: states were expected to bring about legislative changes within their jurisdiction to adopt the provisions of PESA. Most states do not have such an operational law, because of which the effect of PESA has not reached most of the scheduled areas. For example, in Rajasthan, though the formal legal vesting of powers in the Gram Sabhas of tribal areas has taken place, no rules or orders have been issued to implement PESA. The Himachal Pradesh Panchayati Raj Act, 1994, has also made similar provisions, though no rules or executive orders have been passed to give effect to the transfer of control over minor water bodies to the Tribal Gram Sabhas. A NGO, Society for Participatory Research in Asia, PRIA, did a comprehensive study in 2004 on the status of PESA in 8 states. Their finding was that PESA is still not implemented in letter and spirit in many states. There are critical issues concerning the provisions of the Act. Many NGOs working in the field of rural development and on decentralization issues have observed that the ineffective implementation of the PESA could be attributed to the following main factors: non-conformity of the state laws. Most state governments have shown reluctance in making amending laws and rules in conformity with the provisions of the PESA. Many laws, such as the law relating to forest, land, water, mining and minerals, land acquisition, money lending, etc., still need to be amended to give proper effect to the spirit of the PESA. Lack of awareness about the PESA. It has been found that there is an unfortunate and complete lack of awareness among the state-level officers as regards the powers vested in the Gram Sabha and the provisions of the 5th schedule. Further, the stereotypical disdain and prejudice fueled by their insensitivity to the traditional democratic values of the tribal society results in these officials becoming the biggest hindrance to the effective implementation of the spirit of the Act. Absence of appropriate rules. Many state governments have either willfully or otherwise neglected to provide adequate and comprehensive guidance for the proper implementation of PESA. The unresolved and unexplained ambiguities in crucial elements of the law have rendered the implementation of the Act difficult. Ambiguity and lack of clarity. The ambiguity and lack of clarity over the jurisdiction and the powers that have been vested in the Gram Sabha, Panchayat, at different levels, has caused great confusion. The overlap between these institutions and the agencies with government officials who have in certain situations retained overriding powers has resulted in the weakening of these bodies, differing interpretation of PESA provisions, the scope for differing and contrasting opinion by different persons, especially with regard to minor forest produce (MFP), and lack of information assistance to the TR1BLS in the scientific collection, processing, value addition and marketing of MFP, is a cause for grave concern. The uncertainty over the scope of MFP and the constant supervision of officials has been at cross purposes with the traditional wisdom in forest conservation. This has led to a watering down of the provisions that are in fact meant to empower the TR1BLS. Some of the suggestions for the effective implementation of PESA include a model legislation and rules for PESA for immediate adoption by the states. Having Schedule V areas will not only ensure uniformity amongst states, but it will also discourage the dilution of the PESA. This will ensure that powers and responsibilities as envisaged under the Act will be truly transferred to the Gram Sabhas. Also, the minor forest produce being so important for the TR1BLS, an explicit interpretation of the term, including the position regarding inclusion-exclusion of nationalized MFPs, should be incorporated under tribals' rights over MFPs. While preparing such rules, documentation and codification of customary laws and practices in the PESA areas would enable the protection and implementation of traditional laws, especially when non-TR1BLS are required to deal with these customary laws and principles. Coordination between different programs agencies such as Joint Forest Management, JFM-CFM, Van Sanrakshan Samiti, VSS, etc. and the Gram Sabhas and Gram Panchayats in the scheduled areas should be strengthened. Greater impetus should be given to awareness generation programs about PESA, including capacity building of tribal communities and training of those involved in development activities in these areas. Certain initiatives have been taken by the central government to revitalize the implementation of PESA. A process to harmonize the state laws, central laws, and centrally sponsored schemes with the provisions of PESA has been taken up by the Ministry of Panchayati Raj. Further, the new Forest Rights Act, which will discussed in Block 4 BLE 004, recognizes the following rights: tenurial security providing relief against the physical and psychological alienation of land which the scheduled tribes and other forest dwellers belong to; livelihood in terms of subsistence agriculture on as-is where-is basis and the ownership of minor forest produce (MFP), including rights to collect, trade and process the same, traditional and customary rights. It is hoped that PESA along with the Forest Rights Act will result in truly empowering people in the tribal areas. In fact, extension of the PESA to the entire country will usher in a new phase of self-governance.
2.8 Summary. Let us now sum the important points discussed in this unit. The Gram Sabha comprises of all adult citizens residing in a village. As the basic unit of direct democracy, a Gram Sabha not only elects the Gram Panchayat but also monitors its actions. The success or failure of the Panchayati Raj system largely depends on how powerful and effective the Gram Sabha is to fulfill the desires and aspirations of the people. We discussed the constitutional status of the Gram Sabha and its functions. We also looked at select state laws which have further empowered Gram Sabhas to take on some administrative functions as well. We also analyzed the functioning of Gram Sabhas and identified issues that need to be addressed to make them more effective. The Panchayats Extension to Scheduled Areas Act (PESA) confers significantly greater powers on Gram Sabhas in scheduled areas to take on responsibilities and actively participate in governance, rather than just monitor the Panchayat. We discussed the powers and functions of a Gram Sabha under PESA. We also analyzed the issues that need to be addressed for effective implementation of PESA. Thank you. Subscribe to our channel for more updates, and we will see you with the next chapter.